applicable, unquote. We also find that whereas His Excellency the President can establish a state office within the ranks of the public service, it requires approval by the National Assembly. Such approval may be achieved by enactment of a statute which provides for the same and further provide an appropriate framework for a cap on the numbers of CASs if necessary. In the end, we are not satisfied that the newly created office of CAS meets constitutional thresholds. Having reached the above conclusion, we are nevertheless still minded to address the issue of numbers. We note that the initial approved complement rose from 23 CASs to 50. By virtue of their salary and hierarchy, we agree with the fourth petitioner that the creation of the offices would come at a substantial cost to the public. The respondents urged us to find that the office is separate from numbers, and that once the office was legally in place, it was beyond the court to look into the numbers or the accompanying wage bill, and that the task fell to other bodies such as Parliament, Controller of Budget, or the Salaries and Remuneration Commission. We have addressed that issue in a separate part of this judgment. The respondents and interested parties urged us to find that once the office of CAS was established, the complement, all number of officers, was at the discretion of either the PSC or His Excellency the President. Our attention was drawn to the case of the Judicial Service Commission, which recently advertised for 6 posts of Court of Appeal judges but hired 7. We distinguish the above example from the present scenario on the basis that at the material time there was a vacancy, and JSC did not overshoot the ceiling of 30 judges set for the Court of Appeal. The respondents and interested parties also relied on the decision in Sheria Mutaani na Shadrack Waboi, Supra. The petitioner, in that case, challenged the employment of 350 persons by the PSC for the position of Accountant 2 in the National Treasury, but when the advertised vacancies were only 250, the petition was dismissed. But that decision can be distinguished for 2 reasons. Firstly, in the instant consolidated petition, the office created is a high public office with substantial salaries and perks. And secondly, the Sheria Mutaani case was dealing with hiring of lower cadre of public officers, being accountants too. As we pointed out earlier, in interpreting the Constitution, this court is bound to adopt a purposive approach which seeks to give effect to the true purpose of legislation, unquote, and may examine, and I quote, material that bears upon the background against which the legislation was created. See Gatirao Peter Munya versus Dixon Mwenda Gideji. Kenya had for many years a cabinet consisting of ministers and assistant ministers whose composition or numbers was largely at the discretion of the president. The public clamor for control of the size of the executive was reflected in the draft Constitution of Kenya 2005 by the Constitution of Kenya Review Commission. In the proposed Constitution of Kenya 2005, adopted at the Bomas Constitutional Conference on the 15th of March 2004, it was provided for as follows. The President, in accordance with this Constitution, shall appoint and may dismiss A, the Cabinet consisting of 1, the Prime Minister, 2, the 2 Deputy Prime Ministers nominated by the Prime Minister, 3, not less than 15 and not more than 20 ministers nominated by the Prime Minister, and then B, not less than 15 and not more than 20 deputy ministers nominated by the Prime Minister. The number of assistant ministers in the proposed Constitution thus matched that of the ministers. Murima J in the Okia case had also the following to say on that subject, and I shall not read it. The final report of the Committee of Experts, dated the 11th of October 2010, notes that Kenyans wanted, and I quote, that there be a clear distinction between offices of state and offices of government, unquote. Following public debate, the position of the Assistant Minister was abolished altogether and did not make it to the Constitution of Kenya 2010. It is thus not surprising that the size of the Cabinet Secretaries is now capped at 22. Article 152 of the Constitution provides that the Cabinet shall comprise of A, the President, B, the Deputy President, C, the Attorney General, and D, not fewer than 14 and not more than 22 Cabinet Secretaries. It is therefore our considered view that the creation of a similar office to the Assistant Minister, now in name of CAS, cannot be created in the manner the first respondent and the fifth respondent proceeded. Based on the reasoning set out above, we do not think that it was the intention of the framers of the Constitution to have 50 CASs deputizing 22 Cabinet Secretaries. Furthermore, public participation on the office of CAS was founded on a complement of 23 CASs. Doubt is erased by the following other facts. In the letter of 11th October 2022 by Dr. Joseph Kenywa, Head of Public Service, to the PSC, the Head of State requested the PSC to declare 23 vacancies for CASs. We note, however, that the special issue of Kenya Gazette Notice number 12432, dated 12th of October 2022, and the media advertisement the following day calling for applications from suitable candidates did not set the number of vacancies. Furthermore, the stay in the Court of Appeal preserved the original office created on 24th January 2018. Once that office was abolished on 21st September 2022, the newly created office and complement of 23 office holders could no longer benefit from that stay. Accordingly, the newly created office and fresh complement of 50 had to comply with the Constitution and the criteria set out earlier in Okia's case in order to be lawfully established. They did not comply. For the avoidance of doubt, the entire complement of 50 CASs is therefore unconstitutional. I'll now ask